General principles and characteristic of criminal law. So when we talk about the general principles and characteristic of the criminal law, we are talking about criminalization. What is it that makes the case to be criminal, and what are the characteristic of a criminal case or criminal offense? Now, in looking at that, we have to look at first, as we said, the criminal offense. It is doing something which is prohibited or prohibiting something. So when we talk about criminalization, we are talking about prohibiting something or a prohibition. So there is there is a process, as I said, for a certain act to be considered as a criminal act or as a criminal offense. So, in the criminal offense, there are certain tests that has to be taken for it to be considered as a criminal offense. One, there must be an act. Then there should be a process of that of one taking that act. Then there must be the evidence that one had committed that act, and the court can be able to determine that the act was wrong, or there was no wrong about the act. So when the evidence is overwhelming, and it has been seen that really this person committed a wrong act, that is now that person is considered guilty, or if he is not guilty, then he is acquitted by the court. Then when the court determines the determination of the court, then they are going to give punishment to that person. So there will be imposition of punishment by the court. So the determination of the kind of punishment or level of proportional punishment also has to be considered. It's proportional according to the offense that particular person has committed. So those are the things that are considered in when they are for a case or for an action to be considered as the as a criminal offense. There are five key factors that has to be looked at when criminalization of a certain act. Number one, that they consider what is called a harm to an individual. So when something uh, to be criminalized, there must be something that should be a harm to an individual. Has this action harmed somebody, harmed an individual? So when that is being considered in that, uh, then that becomes the it can be criminalized. Now, when we talk about it being criminalized through what we are saying, that has it harmed an individual, has it affected an individual? Now, also it is debated when they say that a criminal offense, it is a harm to an individual or a harm to a certain group of people. There is also the debate whereby they say no, it can also be the moral conduct. There are certain moral conducts, like in Zambia, homosexuality, it is a criminal offense, which is now considered as a moral conduct. So a crime can be something that it can be the harm to an individual or to the group of people, or it can be a moral conduct, whereby you are doing something which is morally not right, like homosexuality. In the Western, it is opposite. Men and men can get married, but polygamy, it is a criminal offense. It is considered as a moral, immoral act, which is also a criminal offense in the Western countries. So those that is what makes the debate that is a crime only an act or harm to an individual, or it also looked at it as a moral act which you have not offended anybody. Like there are many cases that are moral act, like incest. It's uh, it's a moral act, which immoral act whereby you have not offended anybody, because the these cases which has more to do with moral act, they both are reliable into imprisonment. For example, the incest, it means that the incest, it is sexual between the cross relatives. So now that means that both of them, they are, if there is an evidence that those people committed a crime, both are reliable into for punishment. Same like homosexuality. Those both people are reliable into punishment. And the other example that I can give on the immoral conduct, which brings about the legal judgment or determination of uh, uh, the crime, is corruption, where one receives the bribe and one gives the bribe. That is also can be cited as a criminal. That is a moral criminal, offense. Uh, so that is what one of the first thing when you look at the five factors of determining a criminal offense. The second factor is which can determine the criminalization of something is could it be done in any other regulation. Now, when they look at the act, is it the first thing that they look at is this can this act be sorted out in other laws, in other sections of laws, like the Acts of Parliament and other things, what remedies can be done. So if that requires does not cannot be put into other legal processes, then that is also regulated and made to be a criminal offense. It is also the other question when the criminal offense is or criminalization is done, there must be a question: can this be enforceable? Can this act be enforceable? Like when there was COVID, there was maxing up, and they if you don't mask up, then you are committed you are committing a prohibition. You are committing a crime. But now the question comes about in such cases: is it enforceable? Can they enforce that? So that is where also the challenge of criminalization of something comes about. It is some of the things they are very difficult to enforce. So if it cannot be enforceable, then it becomes difficult to be considered as a criminal offense. Then also, a criminal offense can be a conduct, it should be a conduct that can be defined, where there must be a proper definition of that particular action. So it has to be a definable conduct that can be defined without any challenges. Then also it has to be looked at it as can the punishment be proportional to what this person has done. So you have to look at the proportional of punishment. Does this person deserve the punishment for doing this? So those are the five things that are looked at when they are considering something to be a criminal offense.
Thank you so much for today. I think for now, we have looked at this.